All right, so Phong, thank you for being on the show. Welcome. And I want to start with an introduction, but I'm going to put it in your court. Who are you? What's your background? What's your experience, etc.? You have the lead oar on that.
First of all, thanks for inviting me on, and it's great to be here, Luke. My name is Phong Tran. I'm a partner here at the firm. I've been here for about three and a half years now. My focus here is real estate and business litigation. I've had a little bit about my background. I've had somewhat of a circuitous route getting here. I graduated from law school, UCLA Law in 1999. Started my career as a prosecutor, first at the U.S. Attorney's Office, doing border crimes prosecution, drug smuggling, alien smuggling, that type of thing.
I have to imagine you have at least one crazy story as a prosecutor. There has to be something.
Yeah, and I think they would be sort of crazy for the typical person, but it's quite ordinary, down in San Diego near the border of near Tijuana, right? So I think the first trial I had involved a fellow from Mexico who was bringing drugs across the border, and he didn't have some sort of complicated scheme. He decided to have 10 pounds of cocaine and put it in his underwear and just try to walk across the border, right?
Simple plan.
Exactly. Fortunately, he got nailed, and for whatever reason, he did not decide to plead guilty, and we took that to trial. And what's interesting is one of the factors in which the border the inspector at the border caught this guy is because he has new shoes, and that was unusual for a fellow this coming over the border.
Okay.
Right, and that caught the border inspector's eye, and he was thrown in jail. So I took that to trial, and fortunately it was pretty black and white. You can't get away with having that amount of cocaine.
What was the defense? What did the defense raise?
He was claiming that he was doing it under duress.
It wasn't his underwear.
Yeah.
That was his argument.
Yeah, but that didn't persuade the jury. Had another case, and another common crime that occurs at the border is alien smuggling, and this is truly unfortunate, right? You have these folks that are desperate to come into the country, because their situation is dire, and they like to work in the United States, right? And a lot of these folks will really do anything to come over the country, right? And in this particular case, they're called coyotes, which are basically alien smuggler. They had a sort of an operation in which they would smuggle people across the border in their trucks, not only in sort of the back of the truck, but in the sort of engine block. And they created this compartment in the engine block where a person could fit in, right? And there's all sorts of hazards there. You'd die from heat exhaustion, all sorts of things, right?
Fumes.
Exactly. Again, the people working the border were able to stop this person, and we took that to trial too, and successful in getting a guilty verdict for that person.
I knew there would be some good stories. So thank you. Thank you for sharing.
You're welcome. Then I worked at the city attorney's office, San Diego City Attorney's Office for quite some time. And then, I decided to make the transition to civil litigation. First started doing professional malpractice work, business litigation. Then I worked at one of the largest securities litigation firms in the United States, Robin Geller, where I was doing securities class action litigation. Then, decided to make a transition. Heard of this opportunity, discussed with you, and it was an opportunity I couldn't refuse, and decided to join with you guys. And I haven't looked back ever since.
Well, we can't be more thrilled with that decision. So
Great.
We love having you, and you're a tremendous litigator, and you bring so much to the firm. And that's really why I wanted you on this show, specifically on this topic. And the topic today is partnership disputes. Mm-hmm. And when we talk about partnerships, I don't necessarily mean they have to be the legal definition of partnership,
right,
but co-owners, individuals coming together, forming a company.
Mm-hmm.
And I want to bifurcate it because I believe there's two things. One, before a partnership dispute or an owner dispute happens, are there things that individuals can do before they get into that relationship? Any protections? And then part two, if things go south,
Mm-hmm.
what does that look like typically?
Right.
What can you expect?
Right. And, I think the analysis starts on what sort of business entity it is, whether it's a partnership, LLC, corporation, that type of thing. That's all guided by, certain things such as tax considerations, considerations of liability, and, how the business is going to be run ultimately. When we look at a potential case in which a dispute between ownership arises, the first thing we look at is sort of the documents, the governing documents for the type of business, whether it's a partnership agreement or a operating agreement for an LLC, that sort of thing. And those agreements, that exists amongst the business owners sort of dictates on how, what the purpose of the business is and the roles and responsibilities of, the partnerships or the members of the LLC are.
Well, I'm glad you brought that up because quite frequently what I see is newer companies, I mean, even if they have capital, before they really start making money,
Mm-hmm.
it's these friendly deals.
Mm-hmm.
Everyone's friends, kumbaya, and they often cut corners on those formation documents.
Right.
They go online, they get a generic one, and 9 times out of 10, that's fine until it's not fine,
Exactly.
and those documents become disasters.
Right.
So, speaking to that, how important is it for the owners coming together to really shore up those agreements, customize them, make them actually applicable to what they're doing?
Right. I mean, you go on Google and search for, business entity documents or partnership agreements, and you get a large volume of, these companies just generating these draft sort of agreements.
It's
right?
like $3 a document.
Right, right. And that really doesn't benefit or behoove the partners or, the members of the LLC, really, because when you have a business, you got to really tailor the partnership agreement or the operating agreement to the ultimate goal of the business. What do you hope to accomplish? What is each partner or member's role in the business? What's the capital contribution? What happens if a dispute arises? What happens if a partner decides to leave? What happens if we need new partners? So there's all sorts of contingencies that business owners, business partners need to look at when diving into these documents, and it really benefits them to get a tailor-made, customized partnership agreement or operating agreement that's prepared by a experienced attorney.
Yeah, no, I couldn't agree more. And let's speak to the dispute factor, because that's one thing that no one wants to discuss initially.
Right.
Because everyone is excited, they're psyched, they have this new product, they have this new opportunity. And in their mind, you talk to the individuals, there's no dispute. I've known this individual for 30 years.
Mm-hmm.
We've always worked well. That's fine until all the money starts to roll in.
Right.
There has to be this mindfulness of, okay, even if it's perfect now, what if it's not?
Mm-hmm.
And what's your dispute resolution if things do go south?
Yeah.
Which they might. And that's not
Right.
to be negative about it or cast doubt on the company
Right.
or the individuals.
Right.
But it's just being conservative. It's
Right.
a risk-adverse approach,
Right.
which I think every business owner going into these relationships, you need to check that box.
Right. And I think it'd be helpful sort of to provide kind of a 30,000-foot view of what type of disagreements or disputes that could arise among partners or members of an LLC, because I think that's helpful to guide the conversation. First of all, you may have a contractual dispute, a dispute regarding the partnership agreement. Theoretically, the partnership agreement should outline the roles and responsibility of a partner. But what if one partner feels that the other partner is not pulling its weight? That he or she is not serving the partnership and is in breach of the agreement. That's one sort of a dispute that could arise.
Which tends to be frequent. I mean, I see that a lot.
Yes.
Where it's the one business owner comes to us, hey, I work 14-hour days, 15-hour days. I brought on all these accounts.
Right.
I'm the one behind the scenes.
Right.
This person is in Turks and Caicos.
Right. Exactly.
For the last 2 months.
Right, and that's sort of hard to be outlined in the partnership agreement, right? You can't just say you got to work a certain amount of hours or can't take vacations like that. And that leads to the sort of the next form of dispute, which is, a partner may disagree on the operation and management of the partnership, right? Like, for example, the example that you raised is if a partner feels that he or she is doing more work than the other partner and is entitled to more of the proceeds, there's a dispute there. And typically these type of disputes over management and control can arise in good times or bad. If there's a drop in revenue, invariably, one partner may say that, again, you're not pulling your weight. You need to get out of the partnership. Or even in good times, when the company is booming, there's a increase in revenue. There may be a disagreement or dispute on, whether we should pay our employees more, whether we should provide benefits, and the partners may disagree as to that. So it could happen in good or bad. Now, the third type of partnership dispute that we're seeing, or we commonly see, is disputes involving breach of fiduciary duties. One partner may feel that the other partner is misappropriating funds, embezzling, fraud, that type of thing. I mean, those are serious allegations, right? There could be a dispute over the misuse of the IP of the company, trade misappropriation. Again, that would be a form of
right.
Fiduciary duty, breach of fiduciary duty as well. Because, the underlying rule is basically a partner has to look out for the goals of the partnership as a whole and put that above their personal interests. And, in many cases, that's not the case. And I guess the fourth type of dispute that we commonly see is when, when one partner decides to leave, or, worst case, a partner passes away. Is there a succession plan? What happens? Does a partnership agreement call for dissolution of the partnership?
What's the exit strategy?
Exactly.
Right.
The exact exit strategy. That's right.
Yeah. So the other thing, so I sort of honing in on the embezzlement.
Yes.
That's always, as attorneys, that's kind of a fun one because it's there's a lot there. There's a lot of emotions.
Right.
There's a lot for us to do.
Mm-hmm.
So let's run a scenario where you have that partner who's grinding away 15, 16 hours. Their embezzling partner is in Turks and Caicos. Right. I don't know why I choose there, but I don't know. It just seems fitting.
Right.
What does that partner do? What is the first step? What does that look like? What would you do? I mean, you're the litigator.
Right.
He or she comes to you and says, hey, this is the problem. Here's evidence of the embezzlement.
Right.
Here's our Amex card that's being charged every day at a clip of $5,000.
Mm-hmm.
It's not going towards the benefit of the company. What sort of is your attack plan at that moment?
Right.
And it's going to depend, but general sense.
Yeah, and it does depend on the circumstances, but generally I think you would be wise to consult an attorney, right, and come up with a strategy on how to address the situation. And if that attorney would be me.
Yes, you're the attorney. You're
right.
the attorney on this one. This hit your desk.
Ask that partner, what is the ultimate goal that you hope to achieve in this thing? Do you hope to, get this partner out? Do you hope to dissolve the business, that sort of thing? Or do you hope to recover those funds, that sort of thing, right? And I think you would be wise to sort of do a forensic accounting of the books and figure out how much of this money is being misappropriated, right? And then again, you'll have to take a look at the foundational documents, the partnership agreement. What does it say about this sort of thing? Is there some sort of dispute resolution mechanism? I mean, in many partnership agreements, there's a mediation provision. Arbitration provision, that sort of thing. But
right, and you have to, sorry to interrupt, but you have to be very careful with that.
Right.
Because even if the partner comes to you and says, Phong, I want to move forward, I want to file suit immediately.
Right.
That dispute resolution section could dictate otherwise.
Yes.
It could say, hey, before you initiate any sort of litigation, you have to go to mediation first.
Right.
And if you don't, you may waive certain rights. For example, you'll waive your right for attorney's fees.
Right.
Right. So you have to be very careful on those foundation documents.
Right.
Or the lawyer does specifically, right, to
right.
make sure that whatever attack plan is engineered,
Mm-hmm.
it's consistent with those foundation documents.
Right.
Which ties back to what you said earlier, how important it is for the partners to sit down and really identify, okay, if the things go south, what is our resolution mechanism? What's
Right.
reasonable?
Right.
And, I've even seen provisions where there's a safe harbor provision. There's a cool-off period.
Hmm.
It doesn't even go right into mediation. There's a precursor to that where it's like the parties have 30 days to informally attempt to resolve the dispute.
Right.
Notices go back and forth. I don't
Right.
think that that's unwise.
Right.
Right? It's sort of if you can avoid litigation, avoid it.
Mm-hmm.
And if reasonable minds can come together to reach a solution, I think that's always best.
Right.
Best for the company and best for resources.
Right.
But again, it goes down to that foundation document.
Right.
What does it say? And then if it's silent, that's even worse.
Right. And, we as the attorneys and will need to do full due diligence and be aggressive about that. And, as I mentioned, if that requires getting a forensic accountant to go through the book, so be it, But there needs to be a full investigation of what's going on, review the agreements, review the paperwork to make sure, to ensure that the partner that you're representing is protected and to make sure that loss is stopped.
Right. So switching gears now, that was embezzlement. I mean, that's pretty egregious.
Mm-hmm.
But going to something a little bit more gray, and I see this a lot, and this goes also to the foundation documents, but it's where one partner thinks that they're carrying more weight than the other.
Yes.
And you said something interesting. You said it's sort of sometimes hard to determine that.
Right.
Right. So what would you look at? I mean, what would be a clear situation where one partner or one owner is doing all the heavy lifting, and it's clear that the other one is not?
Right.
Are you looking at it from a breach of fiduciary? When does that lack of work
Mm-hmm.
trigger a breach of fiduciary, or what's your analysis on that? What would push it over to the edge to become you're just annoyed
Mm-hmm.
to a viable cause of action?
Right.
Their failure to work is now hurting the company.
Right.
What's your approach on that?
That's a great question, and I think it's important to step back and think about the situations or the circumstances in which the business is formed. Typically, these partners coming to the business with the best intentions, right? We have a great idea for the market. We have some great services to offer. Let's say it's a partnership of two people. We're gonna kick butt. We're just gonna really work hard and make sure this partnership excels.
Yeah,
right?
they have a great product.
Right.
They invented the hoverboard.
Right.
Not the hoverboard in the mall, the one in Back to the Future 2, the actual hoverboard, right? That's a tremendous product.
Right.
So you can imagine two individuals, how excited they would be to bring that to market.
Right.
They want to jump in. They want to get it on Amazon. They want to get it in the mall. They want to just flood the market with it.
Right.
But there's a point in time where they have to pause.
Right.
And sort of, okay, let's take a breath.
And let's use that hoverboard analogy. Let's say one person is responsible for designing the technology, the hoverboard. The other is responsible for sales, generating sales, and trying to sell that hoverboard, right? And that's delineated in the partnership agreement, and it seems pretty straightforward. But let's say this hoverboard company booms, and they're selling 100,000 units each year.
No, it'd be a day. I think that would be a day.
Right. Yeah. They hire sales staff, staff to develop the hoverboard and its technology, manufacturing, all that, and maybe the sales guy starts slacking off and isn't doing his job. What's the other partner going to do, right? That's not always completely outlined in the partnership agreement, and maybe the partner that's responsible for manufacturing is thinking that the other guy's dead weight. So what are he or she's options regarding that?
Yeah, because there seems to be a point where the metric or what you're analyzing is, okay, they're slacking off.
Mm-hmm.
It's not really, you can't really attach any sort of data to that.
Right.
Versus the first 12 months of operations, we saw this huge uptick.
Right.
And in their vertical, in their wheelhouse, you just see this huge downslide.
Right.
Right. That seems to me to be a point where you could isolate, hey, there's something different.
Mm-hmm.
This is in their strike zone.
Right.
And all of a sudden they're not performing. And not only are they not performing, we have data to back that.
Right.
We can show this is your responsibility. This is our client's, wheelhouse and this is what they do. But at least where you stand in the company, we have data to back
Right.
a huge decrease.
Right.
Does that get you in sort of that breach of fiduciary at that point, or at least can arguments start to be formulated around that?
Right. And, I think those data, that data and those sort of metrics can be helpful. But, if the partnership agreement is vague and it doesn't provide for a certain amount of units sold, that could be a challenge, right?
Precisely.
And I think one of the things we'll have to consider, Luke, though, a lot of these founders of these companies, partners of these companies, they started off as friends, friendly acquaintances, right? And they have these type of disputes. It's almost like a divorce, right? So there's this emotional component too that we of the lawyers have to address, right? There may be some underlying issues too, more than just money and metrics, right? And as lawyers, sometimes we serve as therapists and have to dig in and address those issues as well.
Well, I like that point because it is a marriage.
Mm-hmm.
It's a business marriage,
right?
Ultimately, right?
Right.
It's like the whole prenup discussion. A
Right.
lot of people don't like to have that discussion,
Right?
and I'm not drawing an opinion on that. But when it comes to business,
Mm-hmm.
to have that discussion at the forefront, it saves you a lot of headache and heartache down the road.
Right.
So but I understand the emotional part of it too,
Right.
Right? Because it's two individuals; they're very excited. Blood, sweat, and tears go into this thing.
Right.
Things go south. There's typically a lot of anger,
Right.
and animosity. So the lawyer has to step in, at some point address that anger, that animosity, and almost contain it,
Mm-hmm.
and pull it outside of the dispute.
Right.
And then you start looking and you distill it to, okay, I understand the hatred, I understand the venom, but putting aside the venom, legally this is your framework.
Right.
That's the approach. And to get there, though, you need that foundation document. You need those definitions early on, or that framework at the forefront.
Right, and that was your first point, right? And you want a strong partnership agreement. You want a strong operating agreement. But even the strongest partnership agreement doesn't address all the contingencies and circumstances that happen, right? But you can do your best and try to prepare that document.
All right, so I'm going to do a final note. If you were to make 4 recommendations to 2 individuals who are about to launch the hoverboard, they haven't launched yet, but they have it. That's their product.
Mm-hmm.
What would be the top 4 things on that list?
First, I think before even going to see a lawyer, I think these 2 potential partners and founders of this company should really think about their objectives and goals for the company. What do they hope to achieve? What do they hope to accomplish? Is it a certain revenue stream? Do they hope to get bought out later on? That sort of thing.
Oh, I love that. So it's an objective at the outset.
Right.
Is it world domination? Is it licensing? Is it an eventual buyout?
Right.
Or is this just a cash cow for the rest of their lives?
Right. Right.
All right. So objective. I like that.
It could be a fly by night thing, right? I think the second objective and a corollary to the first would be, what is the roles and responsibility for each of these founders, right? Is one guy responsible for the management operation side? Is one guy responsible for sales? And that should be delineated in the partnership agreement.
All right. So it's objectives and what is the lane, or what's the strike zone of each
Right.
individual in the company.
Right.
Okay.
Right.
Third.
And I guess third would be to consult a lawyer in this field to prepare that ironclad partnership agreement that sort of delineates the roles as well as the function of the company, that sort of thing.
All right. I got a quick question there, though.
Yeah.
Do they get separate lawyers, or do they retain one lawyer? What do you recommend?
Typically, I think you can go with one lawyer, but if there may be some issues, two may be appropriate as well. But
Case by case.
yeah, case by case, right?
Okay.
And I think the partnership agreement needs to address the objective of the company, the goals of the company, the roles and responsibilities of the partners, dispute resolution, capital contribution, that sort of thing. And there's a myriad of other stuff that needs to go in there. But those are some of the foundational issues, right?
No, I like that. So before they meet with the lawyer, they identify objectives, they identify strike zones,
Mm-hmm.
they meet with the lawyer or lawyers, they start to memorialize that agreement.
Right.
I love that. What
Right.
about number 4? What's the last recommendation?
It's perhaps premature, but some succession planning. What's going to happen if one partner decides to leave, or they want to add other folks. Is there a dissolution provision in the partnership agreement? What happens if there's a disagreement? That sort of thing.
I love it.
Yeah.
All right. Good stuff, Phong. Well, thank you so much for being on the show, and hope to get you back soon.
It's a pleasure. Thank you, Luke.
Of course.